Hi, I'm Melissa Brisman, and I'm going to be talking to you today about the New York surrogacy law. First, I want to introduce myself. I've been working with CNY for a long time. I'm an attorney and I practice reproductive law. I also have an agency, Reproductive Possibilities, that does approximately 100 to 200 surrogacies a year, where we find and manage the gestational carrier process. My law firm, Melissa Brisman, does various aspects of reproductive law: carrier contracts, sperm donation contracts, ovum donor contracts, parentage and birth orders, and adoptions. And my contact information will be on the screen if you wish to ask me any questions at the end. But today we're going to be talking about the Child Parent Security Act, which just became effective. Okay, next slide. So here's my contact information, and basically there's some information that you should know in the beginning is that this is not really legal advice for any specific person, so you need to make sure that you contact your lawyer if you are going to be undergoing any sort of third-party reproductive treatment and not just rely on these slides. Okay, next. Next. So the Child Parent Security Act was signed on April 3rd, 2020, and it just became effective on February 15th, 2021. The Child Parent Security Act covers a range of different things. Today, we're going to be talking about surrogacy, but the law did change a number of things. It changed the way surrogacy agencies are regulated in New York, escrow agents, embryo disposition, posthumous conception, and it also addresses voluntary acknowledgments of parentage. So just so you have a little bit in the beginning, and know a little bit about the act, I just wanted to make one comment. Is an embryo disposition agreement is basically where people are getting divorced or splitting up and they want to allocate who gets the embryos and who is the parent. It used to be that if you jointly made embryos, you couldn't give away your parental rights upon divorce. But now under the act, if it's in writing and you each have your own lawyer, then you can transfer legal rights upon divorce and cut off one person's rights to visitation and child support and make somebody else the sole parent of those embryos. For instance, if a wife wants to use the embryos after she divorces and the husband wants to give them, but he doesn't want any child support obligations. So that is one thing under the act that you should know about. Next slide. Okay, so the Child Parent Security Act, what does it do? It changes the law for surrogacy in the state of New York. Something that is unique about it is that even though we're talking about gestational carrier and gestational carrier's spouse or intended parents, it uses the word surrogate in the act. So it's a gestational surrogate or a gestational surrogate spouse. Genetic surrogacy, or what we call traditional surrogacy, where the person is genetically related to the baby, is still void and against the public policy of New York. So paid traditional surrogacy still can result in monetary penalties in New York and classified as a felony. So in order to go under the Child Parent Security Act, there's certain aspects of the law that your agreement must have in order to be enforceable. If a provision of the agreement is not enforceable under New York law, that won't mean that the contract is illegal. It will just mean that the contract won't be enforceable. So we want to talk about what makes for an enforceable surrogacy agreement. Next slide. So basically, we want to know who can enter into a surrogacy agreement. So in New York, under the act, the intended parents can be single, married, or unmarried. And any gamete can be used to achieve pregnancy, including donor embryos. The thing that we have to remember is that the egg cannot come from the surrogate, as that would be what we would call traditional surrogacy, which is not permitted under the act. However, if you're a single woman who's 54, you can use donor egg, donor sperm, and that is permitted under the Surrogacy Act. So a new part of is, what are you going to do? So we have a lot of patients that come to us who say, I am splitting from my husband. I'm not getting any younger. I really want to do surrogacy under this new act, but my divorce might not be final for 2 years. So under the act, as long as you have a judgment of separation or you haven't been living with your spouse for 3 years, you can enter into a surrogacy arrangement without him or her. When you enter into a surrogacy agreement in New York, there are certain things that must be in the agreement, basically to make the agreement enforceable. So that's called, one of the things is called the Surrogate Bill of Rights. And the Surrogate Bill of Rights are protections for any surrogate entering into an agreement in New York. So it is pretty hard for intended parents to meet the requirements of a compensated surrogacy arrangement under New York law. So I want to go through them, but one of the things you might want to think about when you're looking for a compensated surrogate is that if you find that compensated surrogate living in the state of New York, in order to make your agreement enforceable, you may have to add all of these things, which can make it a little bit more expensive. So I will go over the things that you need to add, but the other things that you need to know are intended parents. At least one intended parent must be a U.S. citizen or a lawful permanent resident, and at least one intended parent must have been a New York State resident for at least 6 months. So for instance, let's say you're going to CNY and you live outside the state of New York. You don't want to get a surrogate in the state of New York because you don't live in New York, and because of that, your agreement may not be enforceable. So the surrogate must be at least 21 years of age. They must be a U.S. citizen. They are not required to have been given birth previously, but they should have. They must be a New York State resident for at least 6 months. She cannot provide her own egg to achieve pregnancy, and she has completed a medical evaluation. Psychological is not required but suggested, and she has to have given fully informed consent. So the surrogate also must be represented by independent legal counsel. She must be enrolled in a comprehensive health insurance policy that extends throughout the duration of the pregnancy and for 12 months after the birth of the child. She must also have life insurance for up to 12 months after the birth of the child, and the amount is $750,000 that you must obtain. So under the Bill of Rights, which we talked about in the beginning, the surrogate has to have the right to make all health and welfare decisions regarding her pregnancy under New York law, meaning she has the right to choose whether to undergo a C-section, have a multiple embryo transfer, have an abortion, have a termination. She has the right to ask for mental health counseling for issues related to the delivery and the surrogacy, and the intended parents must pay for that counseling. So I want to go over these in a little bit more detail. So for the life insurance, intended parents are responsible for the expense of the life insurance under New York law, disability and mental health counseling, and it's a minimum of $750,000, and it has to be in place prior to the embryo transfer and continue for 12 months after. Legal counseling chosen by the surrogate to represent her and her spouse throughout the delivery and termination must be paid for. In the event of a dispute, it is possible the intended parents may have to pay for her legal fees. And intended parents must also execute a will naming guardians and authorizing the executor to perform financial obligations of the parents under the surrogacy agreement. So basically, if you are using a New York clinic, you don't have to have New York law govern your contract. But if you do have a New York surrogate and she's delivering in New York and the parents are from New York, you're going to have it under New York law. And if she's compensated, you have to be aware that it might cost you more money because you're going to have to pay for all these things that you don't have to pay for under other states' law. So the compensation that you are paying also must be placed in an independent escrow account. And the surrogate agreement under New York law has to include a notice that the surrogate's ability to obtain any public benefits, meaning welfare, food stamps, may be affected by the amount of money she receives in the agreement. If you have an altruistic surrogate, so that's what we refer to as a non-compensated surrogate in New York, she may waive her right to have the parents pay for her life insurance, health insurance, legal counsel, and certain other expenses related to the agreement. And that the reason that's in there is because if it's a sister or a family member, the state thought that she doesn't need as many protections as a paid carrier may need. What happens if you do a surrogacy agreement in New York and it doesn't have all of these things in it? If it does not meet these requirements, it's not enforceable. However, the court shall still determine who goes on the birth certificate and parentage based on the best interest of the child. So, absence of a genetic connection to the child also won't be a basis to deny intended parents. So if you're all in agreement and you don't have an enforceable surrogacy agreement, you can still get a pre-birth order naming the parents as the parents on the birth certificate and leaving off the gestational surrogate from the birth certificate. So also, there's also a section in the law on conflicts of interest. So an agency has to keep funds in an escrow account separate from their operating accounts, and they may not pay the clinic directly. They also cannot be owned or managed by the attorney or a party to the surrogacy agreement. And they have to ensure that all the parties to the agreement are provided with the Bill of Rights. And we're going to go over that a little later. So here we go, the Bill of Rights. So what are the Bill of Rights? So these are exactly copied from the Department of Health website, and you must provide this to any surrogate. The surrogate has a right to make all health and welfare decisions regarding herself and her pregnancy, meaning she has the right to abort or not abort. She has a right to choose her healthcare practitioner, whether to terminate or continue the pregnancy, and whether to retain the number of fetuses she's carrying. She has a right to independent counsel, and again, if she's paid, these fees will be paid for by the intended parents. She has the right to mental health counseling and a comprehensive health insurance policy that covers behavioral health care and covers the cost of psychological counseling. She has the right to health insurance that covers preconception care, prenatal care, major medical treatments, hospitalization, and behavioral health care for up to 12 months after a birth, miscarriage, stillbirth, or termination of the contract. She also has the right to be reimbursed for the cost of the insurance and all co-payments for 12 months after birth. Again, she has the right to life insurance, and that's a term life insurance policy that is to extend also after the child's birth, stillbirth, miscarriage, or termination of the agreement. If the carrier wants to terminate the agreement prior to achieving pregnancy, she can at any time without any penalty. After the termination, the parents will still be responsible for any outstanding expenses. After a surrogate has taken medication or had an embryo transfer, she can only terminate if it is determined that she is not pregnant. Once the carrier is pregnant and you have an enforceable agreement, you can get a judgment of parentage. Now, basically what that is that's where one of the parties resides or the child is born. You would go into court and you would say, okay, one of us lives in New York. We had representation. We voluntarily entered into this agreement. We would like the parents to be put on the birth certificate. So the judgment will declare that the surrogate and the spouse are not the legal parents of the child, that the donors, if any, are not the legal parents, that the surrogate and the spouse will transfer custody of the child as soon as the baby is born, if that has not already occurred, and that the intended parents will assume responsibility for maintenance and support immediately upon the birth. And it orders the local registrar to place the intended parents on the birth certificate of the child. So if you are going to a clinic and you want to know when you can get started with paid surrogacy in New York and when you can start doing it in New York, the surrogacy programs that this regulates are programs that do business in the state, anybody who is acting as a party to an agreement in the state, and the medical procedure occurs in the state. So basically, that means if you're going to have a transfer in New York State under a New York agreement, you have to make sure that the agency that you're using is licensed in New York. Because now, under the new law, anybody who enters into New York from a matching program, they have to be a licensed surrogacy agency. So basically, if you want to enter into an agreement in New York, you want to make sure a few things. It is in your best interest to obtain the judgment of parentage based on the intention of the parties if you cannot meet all of the requirements of an enforceable New York agreement. And you also, it is in the best interests of the parties, if they want to save money, to go to a surrogate-friendly state where one of the other parties resides other than New York, and obtain the judgment in that state so that that judgment can be presented to New York. And that will basically save you a little bit of money and not having to meet all of those requirements under the New York law. So basically, if you want to have a New York agreement, you have to make sure that all of the requirements are being met. That means that you have the surrogate bill of rights presented, you buy the life insurance, the health insurance, the counseling, and you give the carrier discretion over a lot of decisions of our health and welfare. That is not the case in a lot of other states. So if you're worried about any of those things, you're going to want to seek your carrier residing outside the state of New York. Does anybody have any questions? You can put them in the comments if you do. I'll give it a few minutes just to see if anybody does. Okay, I'm not seeing any comments this evening, so that was a very, very brief summary of the New York law. If you have any questions, you can visit us at reproductivepossibilities.com. You can send us an email or you can call the office.